Requirement 3. Consideration. We saw in earlier videos that the three essential elements of a contract are 1. Agreement, 2. Intention, and 3. Consideration. In this video we focus upon the third requirement, consideration. An agreement is not a contract unless both parties to the agreement have paid or promised to pay a price. That price is called consideration. Consideration then does not mean thoughtfulness or kindness. It means the price paid for the other person's promise. According to the law of contract, a promise is not enforceable unless the person to whom the promise is made has paid a price for that promise. The law does not enforce gifts, it only enforces bargains. If I promise to give you a car and I don't keep that promise, you cannot sue me for breach of contract because you did not give me anything in return for my promise. But if I promise to transfer ownership of a car to you in return for you giving me $10,000, that is an exchange. You have provided consideration for my promise, and we will have a contract. The price paid for another person's promise can take a variety of forms. It can be the payment of money. It can be the provision of goods. For example, I promise to give you a car in return for you promising to give me 2 motorcycles. It can take the form of the provision of a service. For example, I promise to give you a car in return for you renovating my home. It can take the form of the undertaking of an onerous obligation. For example, I promise to give you a car in return for which you promise to take on a debt that I owe to another person. It can take the form of refraining from doing something. So, for example, I promise to give you a car in return for you promising not to sue me. And, of course, the consideration can take the form of a promise to do any of these things. I promise to give you a car in return for your promise to pay me next week. In Carlisle and Carbolic Smokeball Company, the Carbolic Smokeball Company promised to pay a reward. What was the consideration provided by Mrs. Carlisle for that promise? The court explained it was not the money paid by Mrs. Carlisle for the Carbolic Smokeball. That was a separate exchange. Mrs. Carlisle paid the money for the smokeball and she was given the smokeball. Here the question was, what was the price paid by Mrs. Carlisle for the promise of a reward? And the court explained that Mrs. Carlisle, following the instructions, using the product 3 times a day for 2 weeks, was undertaking an onerous obligation and counted as consideration. The court therefore concluded in Carlisle and Carbolic Smokeball Company that all 3 requirements were satisfied. There was an agreement between the parties. Those parties did intend that agreement to be legally enforceable, and Mrs. Carlisle had provided consideration for the Carbolic Smokeball Company's promise of reward. There was a contract between the parties, which the Carbolic Smokeball Company had breached, entitling Mrs. Carlisle to a remedy. Consideration need not be adequate. This means that the law does not expect the price paid for another person's promise to be a fair price or an appropriate price. As long as the price has some legal value, the consideration is valid. So, for example, if I promise to give you a car in return for your promise to pay me $10, $10 is clearly not adequate consideration, not for a motor vehicle, but the law is not concerned with the adequacy of the consideration. The consideration does have some legal value, and therefore it is a valid exchange. The contract does exist. Consideration need not be adequate, but it must be sufficient, by which we mean the consideration must have some legal value. A vague promise, for example, does not have any legal value and therefore does not count as consideration. Past consideration does not have any legal value. Past consideration is a price paid before the promise was made, and performance of a legal obligation has no legal value. Doing something you are already required by law to do does not count as consideration. This leads to the rule in Folks and Beer. Part payment of a debt is not sufficient consideration for a promise by the creditor to waive payment of the balance of the debt. For example, if you owe me $10,000 but you are unable to pay the full amount, you approach me and you offer to pay $6,000, and I, being kind, agree to waive the balance. I agree to forgive you for the other $4,000. Can I change my mind? can I break my promise to waive the debt? The question would be, if I have promised to waive repayment of the $4,000 balance, what was the consideration that you provided for that promise? Paying the $6,000 does not count. It's a prior legal obligation. You already owed me $10,000. Therefore, paying the $6,000 does not count as consideration for the promise to waive the $4,000. On the other hand, when a creditor promises to waive the balance of a debt, the debtor will have provided sufficient consideration for the creditor's promise if the debtor accompanies the part payment with additional consideration. Recall that additional consideration can take a variety of forms. If in our previous example I said to you, you no longer have to repay the $4,000 balance, if you had then paid for that promise by perhaps washing my car for me, then we would have a bargain, and my promise to waive the balance of the debt would be enforceable. Now, in exchange of a car wash for forgiving a $4,000 debt, the car wash is clearly not adequate consideration, but recall that consideration need not be adequate. As long as it has some legal value, it counts as consideration, and the promise is enforceable. The creditor's promise to waive the balance of the debt will also be enforceable if the agreement to waive the balance is in the form of a deed. A deed is a formal written contract signed by the parties, and this is the way waiver of debts is done in commercial practice. As long as the contract takes the form of a deed, the requirement of consideration need not be satisfied, and the promise to waive the balance of the debt will be legally enforceable. Another important exception to the rule is the doctrine of promissory estoppel. The doctrine of promissory estoppel allows a contract to be enforced even if no consideration is provided by the promisee. It is an exception to the rule that all contracts must involve the payment of consideration. In Central London Property Trust and High Trees House, the Central London Property Trust owned an apartment building in London which was rented out to High Trees House, which in turn rented out the apartments in the building to various individual tenants. In the early 1940s, London was being bombed by the Germans, and High Trees House found it very difficult to find tenants to rent the apartments in the building. This meant that High Trees House in turn found it very difficult to pay the rent that they owed to the Central London Property Trust. Central London Property Trust agreed to reduce the rent payable by High Trees House by 50% for the duration of the war. High Trees House therefore maintained the arrangement and continued to rent out the building to individual tenants. At the end of the war, Central London Property Trust informed High Trees House that the rent would be restored to its original level, but Central London Property Trust also informed High Trees House that High Trees House had to repay all of the rent that they hadn't been paying during the war. High Trees House objected and insisted that Central London Property Trust had promised to reduce the rent. But what consideration was provided by High Trees House in return for Central London Property Trust's promise? Paying half the rent did not count as consideration because High Trees House already had a legal obligation to pay the full rent. When the matter went to court, the House of Lords acknowledged that High Trees House had not provided any consideration for Central London Property Trust's promise. However, the court also recognised that this meant that Central London Property Trust would be getting away with breaking a promise in circumstances that were clearly unfair. The House of Lords adopted the doctrine of promissory estoppel. The court explained that a promise will be legally enforceable even if no consideration is provided for that promise if three requirements are satisfied. The promisor intended the promisee to rely upon a clear and unambiguous promise. The promisee has in fact relied upon the promise by changing their circumstances, and if the promisor does not keep their promise, the promisee will suffer a material disadvantage, and it would be unconscionable or unfair for the promisor to break their promise. The court decided that all three requirements were satisfied in this case, and that High Trees House could compel Central London Property Trust to keep its promise. The doctrine of promissory estoppel, then, is an important exception to the general rule that a promise will not be legally enforceable unless the promisee has provided consideration or a price for the other person's promise.